is alternative means of alternate dispute resolution, clinical. Csjmu Kanpur University LLB 3 years 4th semester. The course shall comprise of the following. Negotiation skills to be learned with simulated program. Conciliation skills. Arbitration law and practice including international arbitration and arbitration rules. The course is required to be conducted by senior legal practitioners through simulation and case studies. Evaluation may also be conducted in practical exercises at least for a significant part of evaluation. The division of marks. Study and periodical problem solution. 50 marks. On-spot written test at the time of practical. 30 marks, 1 hour's duration. Video voice. 20 marks. Question 1. What is alternative means of dispute redressal? Explain. Alternative dispute resolution, ADR. Alternative dispute resolution, ADR, refers to a variety of methods used to resolve disputes outside of the traditional court system. It offers an efficient and often less stressful way to settle disagreements. Common ADR methods. Mediation. A neutral third party, called a mediator, helps the disputing parties reach a mutually agreeable solution. The mediator facilitates communication and helps find common ground. The outcome is not binding. Arbitration. A neutral third party, called an arbitrator, acts as a private judge. The arbitrator listens to both sides and makes a binding decision. The process is more formal than mediation but less formal than litigation. Negotiation. This is a direct communication between the disputing parties to reach a settlement. It can occur with or without the assistance of lawyers or mediators. Conciliation. Similar to mediation, a neutral third party assists in the dispute resolution process. However, the conciliator may offer suggestions or opinions to help the parties reach an agreement. Advantages of ADR. Cost-effective, ADR is generally less expensive than litigation. Time-saving, ADR processes are often quicker than court proceedings. Less stressful, ADR provides a more informal and less adversarial environment. Preserves relationships, ADR can help maintain relationships between parties. Flexible, ADR offers various options to suit different types of disputes. When to consider ADR? ADR can be suitable for a wide range of disputes, including commercial disputes, contract disagreements, employment conflicts, family disputes, neighbor disputes. In essence, ADR provides an effective and flexible approach to resolving disputes, offering parties an alternative to the traditional court system. Question 2. Explain advantage of alternative dispute resolution, ADR. Advantages of alternative dispute resolution, ADR. Alternative dispute resolution, ADR, offers several key benefits over traditional litigation. Cost-effective. Lower legal fees, ADR processes generally involve lower attorney fees compared to court proceedings. Reduced expenses, court costs, expert witness fees, and other associated expenses are significantly lower in ADR. Time efficient. Faster resolution, ADR processes are typically much quicker than going through the court system, which can take years. Improved productivity, parties can focus on business operations rather than spending time on litigation. Control and flexibility. Party autonomy, parties have more control over the dispute resolution process and outcome in ADR. Flexible procedures, ADR methods, can be tailored to the specific needs of the parties, unlike rigid court rules. Creative solutions, ADR encourages parties to explore innovative solutions that may not be possible in court. Preserves relationships. Maintains business relationships, ADR can help preserve business relationships by fostering cooperation and compromise. Reduces animosity, ADR can help reduce the animosity often associated with litigation. Confidentiality. Private process, ADR proceedings are generally confidential, protecting sensitive information from public disclosure. Preserves reputation, confidential resolution can help protect the reputations of involved parties. Satisfaction. Higher satisfaction rates, parties often report higher levels of satisfaction with ADR outcomes compared to court judgments. Collaborative approach, ADR emphasizes cooperation and finding mutually agreeable solutions, leading to more satisfying results. By understanding these advantages, parties can make informed decisions about whether ADR is the right approach for resolving their dispute. Question 3. Write a brief history of Arbitration and Conciliation Acts, 1996. A brief history of the Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996, was a significant step forward in India's legal landscape. It consolidated and amended the previously fragmented laws related to arbitration, conciliation, and enforcement of foreign arbitral awards. Before 1996, India had a patchwork of laws governing arbitration, including the Arbitration Act, 1940, and the Foreign Awards Act, 1961. These laws were considered outdated and inadequate to address the complexities of modern commercial transactions. Recognizing the need for a comprehensive and modern legal framework, the Indian Parliament enacted the Arbitration and Conciliation Act, 1996. This act was largely influenced by the UNCITRAL model law on international commercial arbitration, aiming to harmonize Indian arbitration law with international standards. Key objectives of the Act: to consolidate and amend the law relating to domestic and international commercial arbitration. To provide a robust framework for the enforcement of foreign arbitral awards. To introduce conciliation as an alternative dispute resolution mechanism. The Act introduced several significant changes, including a more streamlined arbitration process, enhanced powers of arbitral tribunals, provisions for expedited arbitration, clearer rules on the appointment of arbitrators, emphasis on party autonomy in arbitration. While the 1996 Act was a substantial improvement, it was subsequently amended in 2015 and 2019 to further enhance the arbitration ecosystem in India. These amendments aimed to make arbitration more efficient, effective, and user-friendly. In essence, the Arbitration and Conciliation Act, 1996, marked a pivotal moment in India's legal history, providing a modern and comprehensive framework for dispute resolution through arbitration and conciliation. Question 4. What do you understand by arbitration? Arbitration, a brief overview. Arbitration is a method of dispute resolution where parties involved in a disagreement agree to submit their case to a neutral third party, arbitrator, instead of going to court. The arbitrator acts as a private judge, hearing the evidence presented by both sides and then rendering a decision, known as an arbitration award. Key characteristics of arbitration. Consent-based, it requires a mutual agreement between the parties to submit their dispute to arbitration. Binding, the arbitrator's decision is generally final and binding on both parties. Private arbitration proceedings are typically confidential, unlike court cases. Flexible, parties have more control over the process compared to litigation, including the choice of arbitrator and the procedures followed. Advantages of arbitration. Efficiency, arbitration proceedings are usually faster than court cases. Cost-effective, it can be less expensive than litigation due to lower legal fees and court costs. Expertise, arbitrators often have specialized knowledge in the subject matter of the dispute. Preservation of relationships, arbitration can help maintain business relationships by providing a more amicable dispute resolution process. In essence, arbitration offers a streamlined and efficient alternative to traditional litigation for resolving disputes, particularly in commercial and contractual matters. Question 5. What do you understand by arbitration agreement? Arbitration agreement. An arbitration agreement is a contract between two or more parties that stipulates that any disputes arising between them will be resolved through arbitration rather than through the traditional court system. Essentially, it's a pre-agreed method for handling potential conflicts. It outlines the rules and procedures for the arbitration process, including the scope of disputes, what kinds of disagreements are covered by the agreement, the number of arbitrators, how many arbitrators will be involved, the method of appointing arbitrators, how the arbitrators will be selected, the location of the arbitration, where the arbitration proceedings will take place, the applicable law, the legal rules that will govern the arbitration. Arbitration agreements can be standalone documents or included as a clause within another contract, such as a business contract, employment contract, or consumer agreement. By signing an arbitration agreement, parties agree to waive their right to a trial by jury and to have their dispute resolved by an impartial third party. Would you like to know more about the advantages or disadvantages of arbitration agreements? Question 6. Essentials of arbitration agreements. Essentials of arbitration agreements. An arbitration agreement is the cornerstone of the arbitration process. It outlines the terms and conditions for resolving disputes outside of the traditional court system. Key elements of a valid arbitration agreement include 1. Written agreement. The agreement must be in writing to be enforceable. It can be a standalone document or incorporated into a larger contract. 2. Clear and unambiguous language. The agreement should clearly define the scope of disputes covered by arbitration. Ambiguous language can lead to disputes about whether a particular matter is subject to arbitration. 3. Consent of parties. Both parties must voluntarily agree to arbitration. There should be no evidence of coercion or undue influence. 4. Arbitration clause. The agreement should contain a specific clause stating that disputes will be resolved through arbitration. This clause should outline the essential terms of the arbitration process. 5. Number of arbitrators. The agreement should specify the number of arbitrators. If not specified, a single arbitrator is generally presumed. 6. Appointment of arbitrators. The agreement should outline the method for appointing arbitrators. This can include methods like mutual agreement, appointment by a third party, or selection from a panel. 7. Place of arbitration. The agreement should specify the location where the arbitration will take place. This is important for determining the applicable law and jurisdiction. 8. Procedural rules. The agreement may outline specific procedural rules for the arbitration. These rules can cover matters like discovery, evidence, and the conduct of hearings. 9. Language of arbitration. The language in which the arbitration proceedings will be conducted should be specified. 10. Applicable law. The agreement may specify the governing law for the arbitration. This is important for determining the substantive rules that will apply to the dispute. By carefully drafting an arbitration agreement, parties can ensure a smooth and efficient dispute resolution process. Question 7. Ground for challenge of an arbitrator. Grounds for challenge of an arbitrator. The impartiality and independence of an arbitrator are fundamental to the integrity of the arbitration process. A party may challenge an arbitrator under specific circumstances. General grounds for challenge. Lack of impartiality or independence. If circumstances exist that raise justifiable doubts about the arbitrator's impartiality or independence, a challenge can be made. This could include personal or business relationships with a party, financial interest in the outcome of the dispute, prejudiced views or statements, lack of qualifications. If the arbitrator does not possess the qualifications agreed upon by the parties, a challenge can be made. Specific grounds under the Arbitration and Conciliation Act, 1996. Disclosure of circumstances. If an arbitrator fails to disclose circumstances that could raise doubts about their impartiality or independence, a challenge can be made. Challenge by appointing party. A party who appointed an arbitrator can only challenge the appointment after becoming aware of reasons for challenge post-appointment. Time limits. Challenges must be made within a specified time frame after the appointment of the arbitrator or after the circumstances giving rise to the challenge become known. Important considerations. The burden of proof to establish grounds for challenge lies with the challenging party. Courts generally adopt a strict approach to challenges to uphold the finality of arbitral awards. It's crucial to note that the specific grounds for challenge may vary depending on the applicable arbitration rules and the laws of the jurisdiction where the arbitration is taking place. Question 8. Mediation and arbitration. Mediation versus arbitration. Key differences. Mediation and arbitration are both forms of alternative dispute resolution, ADR, offering alternatives to traditional litigation. While they share the goal of resolving disputes outside of court, they differ significantly in their process and outcome. Mediation. Nature: a facilitated negotiation process where a neutral third party, mediator, assists disputing parties in reaching a mutually agreeable settlement. Role of mediator: facilitates communication, identifies common ground, and helps parties explore potential solutions. Mediation process where a neutral third party, mediator, assists disputing parties in reaching a mutually agreeable settlement. Decision-making, parties retain control over the outcome and must reach a voluntary agreement. Outcome, a negotiated settlement, often resulting in a win-win situation. Confidentiality, generally, highly confidential. Arbitration. Nature, a formal process where a neutral third party, arbitrator, acts as a private judge, hearing evidence and making a binding decision. Role of arbitrator, acts as a decision-maker, applying relevant laws and rules to the dispute. Decision-making, arbitrator makes a final and binding decision. Outcome, an arbitral award, which is enforceable like a court judgment. Confidentiality, can be confidential, but depends on the agreement of the parties. Key differences summarized. Feature. Mediation. Arbitration. Decision-maker. Parties. Arbitrator. Outcome. Negotiated settlement. Arbitral award. Level of formality. Informal. Formal. Control over outcome. High. Low. Binding. Non-binding. Binding. In essence, mediation is a collaborative process aimed at reaching a mutually agreeable solution, while arbitration is a more adversarial process where a neutral third party makes a binding decision. Question 9. What should be the place of arbitration? The place of arbitration, a crucial consideration. The place of arbitration is a critical aspect of any arbitration agreement. It determines several key elements of the arbitration process, including 1. Applicable law. The law governing the arbitration proceedings is generally the law of the place of arbitration. This influences the procedural aspects of the arbitration. 2. Court intervention. The courts of the place of arbitration typically have supervisory jurisdiction over the arbitration. This means they can intervene in case of challenges to the award or other procedural issues. 3. Enforcement of the award. The place of arbitration often impacts the enforceability of the arbitral award. Countries that are signatories to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards typically provide for easier enforcement of awards made within their territories. 4. Convenience for parties and arbitrators. The place of arbitration should be convenient for all parties involved, including the arbitrators. It should facilitate the efficient conduct of the proceedings. 5. Neutral ground. In some cases, parties may prefer a neutral location for the arbitration to avoid any potential bias that could arise from holding the proceedings in one party's home country. Key considerations when choosing a place of arbitration. Legal framework. The arbitration law of the chosen place should be supportive of arbitration and provide a clear procedural framework. Judicial system. The efficiency and impartiality of the courts in the chosen jurisdiction are important factors. Enforcement of awards. The country's track record in enforcing arbitral awards should be considered. Cost and time factors. The costs associated with conducting the arbitration in a particular location should be evaluated. In conclusion, the choice of the place of arbitration is a strategic decision that can significantly impact the outcome of the arbitration. Careful consideration should be given to the factors mentioned above to select the most appropriate location. Question 9. Appointment of arbitrator. Appointment of arbitrator. The appointment of an arbitrator is a crucial step in the arbitration process. The method of appointment is typically outlined in the arbitration agreement. Methods of appointment. Agreed upon by parties. This is the most common method. Parties can mutually agree on a specific individual or a panel of arbitrators. It ensures that both parties have confidence in the arbitrator. Appointment by a third party. Parties may designate a neutral third party, example, a professional organization, institution, or individual, to appoint the arbitrator. This method is often used when parties cannot agree on an arbitrator themselves. Court appointment. If parties fail to agree on an arbitrator as per their agreement or the statute, the court may be approached to appoint one. This is usually a last resort. Qualifications of an arbitrator. While there is no strict qualification requirement, the arbitrator should generally possess impartiality, free from bias or conflict of interest. Independence, not affiliated with any party involved in the dispute. Expertise, knowledge or experience relevant to the dispute. Availability, able to devote sufficient time to the arbitration proceedings. Challenges to appointment. If a party believes that an arbitrator is not impartial or independent, they can challenge the appointment. Grounds for challenge may include lack of impartiality or independence, lack of qualifications, failure to disclose relevant information. Role of the arbitrator. The arbitrator's role is to conduct fair and impartial proceedings, hear evidence and arguments from both parties, make a final and binding decision, a vote. The proper appointment of a qualified and impartial arbitrator is essential for the success of an arbitration. Question 11 Court. The Arbitration and Conciliation Act 1996 defines. Section 2E. Court means I. In the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district, and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court, or any court of small causes. 2. In the case of international commercial arbitration, the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, and in other cases, a High Court having jurisdiction to hear appeals from decrees of courts subordinate to that High Court. Question 12. Give the kinds of arbitration. Kinds of arbitration in India. There are primarily two main types of arbitration in India. 1. Ad hoc arbitration. Parties themselves create the arbitration process. No institutional framework is involved. Parties have full control over the procedure, including the appointment of arbitrators, the conduct of hearings, and the making of the award. Offers flexibility but requires more administrative effort from the parties. 2. Institutional arbitration. Arbitration conducted under the rules of a recognized arbitral institution. Institutions provide administrative support, including appointment of arbitrators, case management, and enforcement of awards. Examples of arbitral institutions in India include Indian Council of Arbitration, ICA, Delhi International Arbitration Centre, DIAC, Mumbai Centre for International Arbitration, MCIA, Bangalore Mediation Centre, BMC. Offers a structured process with professional support but may be more expensive. Other classifications. Domestic versus international arbitration, based on the nationality of parties and place of arbitration. Voluntary versus mandatory arbitration, based on whether parties freely agree to arbitration or are compelled by a contractual clause. It's important to note that these categories are not mutually exclusive and there can be overlaps. For example, an ad hoc arbitration can be domestic or international, and an institutional arbitration can be voluntary or mandatory. Question 13. Define the parties of arbitration agreement. Parties to an arbitration agreement. The parties to an arbitration agreement are the individuals, organizations, or entities that agree to submit their disputes to arbitration rather than to a court of law. Typically, there are two primary parties. Claimant, the party initiating the arbitration proceeding by filing a claim or demand for relief. Respondent, the party against whom the claim is made. However, there can be multiple parties involved in an arbitration, such as third-party claimants, additional parties who join the arbitration to assert their own claims. Third-party respondents, parties brought into the arbitration by the claimant or respondent. It's essential to note that the specific terminology for parties can vary depending on the jurisdiction and the applicable arbitration rules. Question 14. Arbitration proceeding. Arbitration proceeding. An arbitration proceeding is a formal process where parties to a dispute agree to submit their case to a neutral third-party arbitrator instead of going to court. This decision is typically outlined in an arbitration agreement. Key stages of an arbitration proceeding. Initiation. A claimant files a request for arbitration with the arbitrator or arbitral institution. The request typically outlines the claims and the relief sought. Formation of the arbitral tribunal. The arbitrator or arbitrators are appointed, either by agreement of the parties or through a designated process. Pre-hearing procedures. This involves the exchange of information, documents, and pleadings between the parties. It may include discovery, depositions, or other fact-finding methods. Hearings. Oral hearings are held where parties present their case, examine witnesses, and provide evidence. The arbitrators preside over the hearings. Post-hearing submissions. Parties may submit written closing arguments or briefs after the hearings. Award. The arbitrators issue a written decision, known as an award, which outlines the findings of fact and law and determines the relief granted. Enforcement. The winning party can enforce the award through the courts if necessary. Key differences from court proceedings. Privacy. Arbitration proceedings are generally private, unlike court cases. Flexibility. Parties have more control over the process, including the choice of arbitrator and procedures. Expertise. Arbitrators often have specialized knowledge in the subject matter of the dispute. Speed. Arbitration proceedings are typically faster than court cases. Question 15. What are the advantages of arbitration? Advantages of arbitration. Arbitration offers several benefits over traditional litigation. Efficiency and speed. Quicker resolution. Arbitration proceedings are generally faster than court cases, saving time and resources for both parties. Flexible scheduling. Arbitrators have more control over scheduling hearings, accommodating the parties' needs. Cost-effectiveness. Lower costs. Arbitration often involves lower legal fees and other expenses compared to litigation. Reduced discovery. The discovery process is typically less extensive in arbitration, saving time and money. Expertise. Specialized arbitrators. Parties can choose arbitrators with expertise in the specific subject matter of the dispute, leading to more informed decisions. Industry-specific knowledge. Arbitrators often have experience in the relevant industry, providing deeper understanding of the issues. Flexibility and control. Tailored procedures. Parties have more control over the arbitration process, including the selection of arbitrators and the rules to be followed. Confidentiality. Arbitration proceedings are typically private, protecting sensitive information. Preservation of relationships. Less adversarial. Arbitration can be less contentious than litigation, preserving business relationships. Focus on solutions. Arbitrators often encourage parties to find mutually agreeable solutions. Finality. Limited appeals. Arbitration awards are generally final and binding, with limited opportunities for appeal. By understanding these advantages, parties can make informed decisions about whether arbitration is the right dispute resolution method for their specific situation. Question 16. Define the arbitral tribunal. Arbitral tribunal. An arbitral tribunal is a panel of impartial adjudicators convened to resolve a dispute through arbitration. It serves as the equivalent of a court in traditional litigation. Composition of an arbitral tribunal. An arbitral tribunal can consist of a single arbitrator. This is the most common form of tribunal. A panel of arbitrators. This is often used for complex or high-value disputes. The panel typically consists of 3 arbitrators, with one serving as the chair. Role of the arbitral tribunal. The primary role of an arbitral tribunal is to conduct fair and impartial proceedings. Hear evidence and arguments from both parties. Apply the applicable law and rules to the dispute. Render a final and binding award. Powers of the arbitral tribunal. The tribunal has broad powers to conduct the arbitration proceedings, including determining its own procedures, ordering interim measures, deciding on the admissibility of evidence, making rulings on procedural matters. In essence, the arbitral tribunal acts as a private court, providing a neutral and efficient forum for dispute resolution. Question 17. Duty of arbitration tribunals. Duties of arbitration tribunals. An arbitral tribunal carries significant responsibilities to ensure the fairness and integrity of the arbitration process. The primary duties include impartiality and independence. Treat parties equally. The tribunal must treat all parties fairly and without bias. Avoid conflicts of interest. The tribunal must disclose any potential conflicts of interest and take steps to ensure impartiality. Due process. Fair hearing. The tribunal must provide a fair opportunity for each party to present its case. Equal treatment. Both parties must be given equal opportunities to present evidence, cross-examine witnesses, and make submissions. Adherence to rules. The tribunal must follow the agreed-upon arbitration rules or the applicable procedural law. Decision-making. Merits of the case. The tribunal must base its decision on the evidence presented and the applicable law. Clear and reasoned award. The tribunal must issue a clear and reasoned award that explains the basis for the decision. Timely award. The tribunal should strive to render the award within a reasonable time frame. Confidentiality. Protect confidential information. The tribunal must maintain the confidentiality of the arbitration proceedings. Other duties. Managing the process. The tribunal is responsible for conducting the arbitration efficiently and effectively. Enforcing procedural rules. The tribunal has the authority to enforce the agreed-upon arbitration rules or the applicable procedural law. By fulfilling these duties, the arbitral tribunal contributes to the efficiency, fairness, and integrity of the arbitration process. Question 18. What is the jurisdiction of arbitral tribunal? Jurisdiction of an arbitral tribunal. The jurisdiction of an arbitral tribunal is derived solely from the arbitration agreement between the parties. This means the tribunal's authority to hear and decide a dispute is limited to the scope of the agreement. Key aspects of an arbitral tribunal's jurisdiction. Subject matter jurisdiction, the tribunal's power to adjudicate the specific type of dispute. Territorial jurisdiction, the tribunal's authority to exercise its powers within a particular geographical area. Personal jurisdiction, the tribunal's power to bind specific parties to the arbitration. Section 16 of the Arbitration and Conciliation Act, 1996. This section explicitly grants arbitral tribunals the power to decide on their own jurisdiction, including challenges to the existence or validity of the arbitration agreement. This underscores the principle of party autonomy and the tribunal's role as an independent decision-maker. Important points to remember. The tribunal's jurisdiction is contractual in nature, stemming from the arbitration agreement. Challenges to the tribunal's jurisdiction are typically raised at the outset of the arbitration proceedings. The tribunal's decision on its jurisdiction is subject to limited judicial review. In essence, an arbitral tribunal's jurisdiction is circumscribed by the arbitration agreement, and its power to determine its own jurisdiction is a cornerstone of the arbitration process. Question 19. Who can be arbitrator? Who can be an arbitrator? Generally, any person of sound mind can be an arbitrator, unless otherwise agreed by the parties. The Arbitration and Conciliation Act, 1996, of India provides broad discretion to parties in selecting an arbitrator. Key considerations. Nationality. There is no restriction on the nationality of an arbitrator. Qualifications. While not mandatory, it is advisable to choose an arbitrator with expertise in the subject matter of the dispute. Impartiality. The arbitrator must be impartial and independent. Any conflict of interest should be disclosed. Availability. The arbitrator should be available to conduct the arbitration proceedings efficiently. Appointment of arbitrator. The method of appointing an arbitrator is usually specified in the arbitration agreement. Common methods include mutual agreement. Parties can jointly appoint an arbitrator. Appointment by a third party. A neutral person or institution can be designated to appoint the arbitrator. Court appointment. In case of a deadlock, the court may appoint an arbitrator. It's essential to select an arbitrator who can effectively and impartially resolve the dispute. Question 20a. Domestic award. Domestic award. A domestic award is an arbitral award made in India under the provisions of Part I of the Arbitration and Conciliation Act, 1996. This means that the arbitration proceedings took place within India and the award was rendered in accordance with Indian law. Key characteristics of a domestic award. Made in India, the arbitration proceedings leading to the award occurred within the geographical boundaries of India. Governed by Indian law, the arbitration is subject to the provisions of Part I of the Arbitration and Conciliation Act, 1996. Enforceable as a decree. Under Section 36 of the Arbitration and Conciliation Act, a domestic award is treated as a decree of a court once the time for challenging it has expired or any challenge has been unsuccessful. Enforcement of domestic awards. To enforce a domestic award, the successful party must file an application in a court of competent jurisdiction. The court then treats the award as a decree and executes it in the same manner as it would execute its own decree. In essence, a domestic award is a final and binding decision rendered by an arbitral tribunal in India, which enjoys the same legal status as a court decree. Would you like to know more about the process of enforcing a domestic award or the grounds for challenging a domestic award? Question 20b. Explain award. Award. An award is the final decision or determination made by an arbitrator or a court in a dispute. It is a formal document that outlines the findings of fact, conclusions of law, and the relief granted to the prevailing party. Types of awards. Arbitration award, a decision made by an arbitral tribunal resolving a dispute submitted to arbitration. Court judgment, a decision rendered by a court of law after a trial or other legal proceeding. Compensation award, a monetary sum granted to a party as compensation for damages or losses suffered. Key components of an award. Parties involved, names and addresses of the parties to the dispute. Arbitration agreement, reference to the arbitration agreement that gave rise to the arbitration proceedings. Procedural history, summary of the proceedings, including hearings and evidence presented. Findings of fact, determination of the facts relevant to the dispute. Conclusions of law, application of legal principles to the established facts. Relief granted, the specific decision or remedy awarded to the prevailing party. Date of the award, the date on which the award was issued. Signatures of the arbitrators, signatures of the arbitrators who participated in making the award. An award is generally considered final and binding on the parties, subject to limited grounds for challenge. Question 21. Describe the difference between foreign award and domestic award. Domestic award versus foreign award. The primary distinction between a domestic award and a foreign award lies in the geographical location of the arbitration proceedings. Domestic award. Origin made within the territory of a particular country. Governing law subject to the domestic arbitration laws of that country. Enforcement generally easier to enforce as it is considered a decree of the domestic court. Example, an award made in India under the Arbitration and Conciliation Act, 1996. Foreign award. Origin made outside the territory of a particular country. Governing law, typically subject to the laws of the country where the arbitration took place. Enforcement requires specific procedures under international conventions like the New York Convention for enforcement in a different country. Example, an award made in Singapore under Singaporean arbitration law. Key differences. Feature. Domestic award. Foreign award. Origin. Within the country. Outside the country. Governing law. Domestic arbitration law. Law of the country where arbitration took place. Enforcement. Generally easier. Requires specific procedures and conventions. It's important to note that the distinction between domestic and foreign awards is crucial for determining the applicable legal framework and the process for enforcing the award. Question 22. What is the form and contents of an award? Form and contents of an award. An award is a formal document that embodies the decision of an arbitral tribunal. Form of an award. Written, an award must be in writing to be valid. Oral awards are not enforceable. Signed, the award must be signed by all members of the arbitral tribunal. In case of multiple arbitrators, the signatures of the majority are sufficient, provided the reason for the absence of other signatures is stated. Contents of an award. While the specific content can vary based on the complexity of the case and the applicable arbitration rules, a typical award includes identification of the parties, names and addresses of the parties involved in the arbitration. Reference to the arbitration agreement, details of the arbitration agreement, including its date and parties. Constituted arbitral tribunal, names and qualifications of the arbitrators. Procedural history, a brief overview of the arbitration proceedings, including dates of hearings and submissions. Summary of claims and defenses, a concise statement of the parties' claims and defenses. Findings of fact, detailed findings of fact based on the evidence presented. Conclusions of law, application of relevant laws and principles to the established facts. Decision and relief, the final decision of the tribunal, including the relief granted to the prevailing party. Costs, allocation of costs, including arbitrators' fees, legal fees, and other expenses. Date of the award, the date on which the award is issued. Additional elements. Reasons for the award. While not mandatory in all jurisdictions, providing reasons for the decision can strengthen the award's enforceability. Interest. The award may include interest on the amount awarded. Interim awards. If any interim awards were issued during the arbitration, they should be incorporated into the final award. The specific requirements for the form and content of an award may vary depending on the applicable arbitration rules and the laws of the jurisdiction. Question 23 is correction and interpretation of award or additional award possible? Correction and interpretation of an award. Yes, correction and interpretation of an award are possible under certain circumstances. Correction of an award. This involves rectifying errors that have crept into the award due to clerical mistakes, computational errors, or other similar oversights. These errors should not affect the substance of the award. Initiation. A party can request the arbitral tribunal to correct such errors within a specified time frame, usually 30 days. Tribunal's power. The tribunal has the authority to make corrections on its own initiative as well. Interpretation of an award. This process is aimed at clarifying ambiguities or uncertainties in the award. It does not alter the substance of the award but merely explains its meaning. Initiation. A party can request the arbitral tribunal to interpret a specific point or part of the award within a specified time frame, usually 30 days. Tribunal's power. The tribunal can also initiate the interpretation process if it deems it necessary. Additional award. In exceptional cases, where the award omits to decide on a matter submitted to arbitration, the tribunal can be requested to make an additional award. This is different from correction or interpretation as it involves a new decision on a previously unaddressed issue. Important points to remember. There are strict time limits for requesting correction, interpretation, or an additional award. The tribunal's decision on correction, interpretation, or additional award is final. These procedures are aimed at clarifying the award, not reopening the merits of the case. By allowing for correction, interpretation, and additional awards, the arbitration process aims to ensure that the final decision is accurate, complete, and understandable. Question 24a. What provisions have been made in Arbitration and Conciliation Act, 1996 regarding statements of claims and defense? Statements of claim and defense under the Arbitration and Conciliation Act, 1996. Section 23 of the Arbitration and Conciliation Act, 1996 specifically addresses the matter of statements of claim and defense in arbitration proceedings. Key provisions. Obligation to file. The Act mandates that parties to an arbitration must submit their claims and defenses in writing. Content. These statements should clearly outline the nature and extent of the claims or defenses being asserted. Purpose. The purpose of these statements is to provide a clear framework for the arbitration proceedings. Flexibility. While the Act mandates the filing of statements of claim and defense, it also allows for flexibility in terms of their content and format. Parties can agree on the specific details of these statements. Importance of statements of claim and defense. Clarity. They help clarify the issues in dispute. Focus. They help to narrow down the scope of the arbitration. Efficiency. They contribute to the efficient conduct of the proceedings. Fairness. They ensure that both parties are aware of the claims and defenses being raised. Essentially, the Act provides a basic framework for the exchange of information between parties in an arbitration, but it also allows for sufficient flexibility to accommodate the specific needs of each case. Question 24b. What is settlement agreement? Explain. Settlement agreement. A settlement agreement is a legally binding contract between two or more parties that resolves a dispute without the need for a formal court proceeding. It outlines the terms of the compromise reached by the parties and serves as a final resolution to the matter. Key elements of a settlement agreement. Clear and concise terms. The agreement should clearly define the rights, obligations, and responsibilities of each party. Consideration. Something of value must be exchanged by both parties, which could be money, property, or other concessions. Mutual agreement. All parties involved must willingly agree to the terms of the settlement. Release of claims. The agreement typically includes a mutual release of claims, meaning that neither party can pursue legal action related to the dispute in the future. Confidentiality. Often, settlement agreements contain confidentiality clauses to protect sensitive information. Common uses of settlement agreements. Employment disputes, resolving issues like wrongful termination, discrimination, or wage disputes. Business disputes, settling contract disagreements, partnership disputes, or shareholder conflicts. Personal injury claims, resolving claims arising from accidents or negligence. By entering into a settlement agreement, parties can save time, money, and emotional stress associated with litigation. However, it's essential to seek legal advice before signing any settlement agreement to ensure your rights are protected. Question 25. What is statutory arbitration? Statutory arbitration. Statutory arbitration is a form of dispute resolution where the arbitration is mandated by a specific statute or law, rather than arising from a voluntary agreement between the parties. In contrast to contractual arbitration, where parties agree to arbitrate their disputes through an arbitration clause in a contract, statutory arbitration is imposed by law. Key characteristics of statutory arbitration. Lack of consent. Parties may not have consented to arbitration but are compelled to do so by the statute. Specific statutes. Several laws in India, such as the Land Acquisition Act, 1894, the Indian Electricity Act, 1910, and the Railways Act, 1890, mandate arbitration for certain disputes. Applicable law. The Arbitration and Conciliation Act, 1996, is generally applicable to statutory arbitrations, but to the extent it is inconsistent with the specific statute, the provisions of the special statute prevail. Examples of statutory arbitration. Disputes related to land acquisition under the Land Acquisition Act. Claims for compensation due to damage caused by electricity supply under the Indian Electricity Act. Matters concerning railway accidents or property damage under the Railways Act. Importance of statutory arbitration. Provides a specialized dispute resolution mechanism for specific areas. Ensures consistency in handling similar disputes. Offers a quicker and more efficient alternative to traditional litigation. In essence, statutory arbitration is a mechanism designed to resolve disputes in specific areas where legislative intervention is deemed necessary. Question 26. What is the difference between arbitral proceeding and judicial proceeding? Arbitral proceeding versus judicial proceeding. Arbitral and judicial proceedings are two distinct methods of resolving disputes. Here's a comparison. Arbitral proceeding. Private, conducted outside the formal court system. Consensual, based on an agreement between the parties. Flexible, parties have more control over the process, including the selection of arbitrators and procedures. Expert-driven, arbitrators often have expertise in the subject matter. Confidentiality, proceedings are generally confidential. Speedier, often resolves disputes faster than court proceedings. Finality, arbitral awards are generally final and binding. Judicial proceeding. Public, conducted in open court. Adversarial, based on the adversarial system where parties present their cases to a judge or jury. Rigid, bound by strict procedural rules and evidence laws. Judge-led, the judge controls the proceedings. Public record, proceedings are public record. Time-consuming, often involves lengthy processes, including discovery and appeals. Appealable, decisions can be appealed to higher courts. In summary, arbitration offers a more flexible, efficient, and private dispute resolution mechanism compared to judicial proceedings. However, the choice between the two depends on the nature of the dispute, the parties' preferences, and the specific circumstances of the case. Question 27. Misconduct is a good ground for setting aside an award. Misconduct as a ground for setting aside an award. Yes, misconduct is a valid ground for setting aside an award. Section 30 of the Arbitration and Conciliation Act, 1996, explicitly states that an award can be set aside if an arbitrator or umpire has misconducted himself or the proceedings. This provision underscores the importance of impartiality and fairness in the arbitration process. What constitutes misconduct? Bias or partiality, if it can be proven that the arbitrator was biased or partial towards one of the parties. Improper conduct, any behavior that undermines the integrity of the arbitration process, such as accepting bribes or engaging in activities that compromise impartiality. Procedural irregularities, if the arbitrator fails to follow the agreed-upon procedure or the rules of natural justice. Burden of proof. The party seeking to set aside the award on the grounds of misconduct bears the burden of proving the allegations. This is a high burden, and the court will scrutinize the evidence carefully. It's crucial to note that mere disagreement with the award's merits is not sufficient grounds for setting aside an award on the basis of misconduct. The misconduct must be proven to have affected the fairness of the proceedings. Question 28. Whether arbitration agreement is discharged by death of the party? Death of a party and arbitration agreement. No, the death of a party does not discharge an arbitration agreement. Section 40 of the Arbitration and Conciliation Act, 1996 explicitly states that an arbitration agreement is not terminated by the death of a party. Key points. Survival of the agreement. The arbitration agreement continues to be valid even after the death of a party. Legal representatives. The legal representatives of the deceased party can enforce or be subject to the arbitration agreement. Continuity of proceedings. The arbitration proceedings can continue with the legal representatives of the deceased party participating. This provision ensures the continuity of the arbitration process and protects the rights of both the deceased party's estate and the surviving party. In essence, the death of a party does not disrupt the arbitration process but merely necessitates the substitution of the deceased party with their legal representative. Would you like to know more about the role of legal representatives in arbitration or the procedure to be followed in case of the death of a party? Question 29. What formalities are required for entitlement of legal services? Substitution of the deceased party with their legal representative. Formalities for entitlement of legal services. The formalities required for entitlement to legal services primarily depend on the specific legal aid scheme or program you are seeking assistance from. However, generally, you would typically need to fulfill the following criteria. Eligibility criteria. Income. Demonstrate that your income falls below a certain threshold as specified by the legal aid scheme. Category. Belong to a disadvantaged group such as scheduled castes, scheduled tribes, or other marginalized communities. Nature of case. The case should generally involve a fundamental human right or public interest issue. Required documents. Proof of income, income certificates, salary slips, or other relevant documents. Identity proof, Aadhaar card, PAN card, voter ID, or passport. Address proof, ration card, utility bills, or other documents. Case-related documents, court notices, FIR, or other relevant documents pertaining to the case. Application process. Application form. Complete the legal aid application form provided by the concerned legal services authority. Submission. Submit the completed application form along with required documents to the nearest legal services authority. Additional considerations. Legal Services Authority Act, 1987. This is the primary legislation governing legal aid in India. State-specific rules. Different states may have additional rules and regulations regarding legal aid eligibility. Free legal aid. In many cases, legal aid is provided free of cost to eligible individuals. It's important to note that these are general guidelines. The specific requirements may vary depending on the jurisdiction and the type of legal aid you are seeking. I recommend contacting your nearest legal services authority for accurate and up-to-date information. They can provide you with detailed guidance on the eligibility criteria and the necessary formalities for availing legal services.